Next matter to come before the court this morning is Brian McAllister versus Myers Industries et al. Good morning.
Good morning.
Each party will have 15 minutes which to present their case. The appellant will retain up to 5 minutes for rebuttal. If you're the appellant, you wish to retain some of that time, let me know when you come up to the podium. I'll keep you track of the clock. I'll keep you apprised of the passage of time. We are being visually and audibly recorded to be posted online, so please try to remain by the podium as much as possible. We have read your briefs and we're ready to proceed. Mr. Gross, I presume that who's the other counsel today?
I'm sorry?
Who's arguing for Filter Specialties?
I am, Your Honor, Ali Razagi.
Okay. Do you gentlemen intend to split your 15 minutes?
Yes, Your Honor. 10 minutes,
10 and 5?
10 and 5.
Okay, great, thank you. All right, thank you. And how about you for rebuttal, sir?
Sure. Good morning, Craig McLaughlin on behalf of the appellant, Brian McAllister, and I'd like to reserve 4 minutes of my time for rebuttal. May it please the court, opposing counsel, appellant Brian McAllister respectfully requests that this court reverse the trial court's decision to grant the motion to dismiss that was filed by Myers Industries, Inc. In addition, Brian requests that the court reverse the trial court's decision to grant summary judgment to Bill Hartwick and his Filter Specialties. In regard to Myers Industries and their motion to dismiss, the trial court granted that motion based on the argument that Brian McAllister failed to state a claim upon which relief can be granted. When analyzing a 12B6 motion to dismiss, obviously both the trial court and in this court, being a de novo review of that decision, we must accept all factual allegations in the complaint as true, must construe any reasonable inferences in favor of Brian McAllister, and it must appear beyond doubt that Brian can prove no set of facts in support of his claim against Myers Industries. Brian brought a claim against Myers Industries, his employers, pursuant to Ohio Revised Code 247501, sometimes referred to as the Employer Intentional Tort Statute. We recognize that when bringing this type of a claim, there is, that notice pleading is not enough. We recognize that like bringing a fraud claim and some other specific types of claims, there is a heightened standard of pleading that is necessary. So based on information that Brian provided, information that was gleaned from the OSHA investigation into this incident that resulted in OSHA citations being issued to Myers Industries, as well as information gleaned from the report that was prepared and filed by an investigator from the Bureau of Workers' Comp pursuant to a violation of a specific safety requirement investigation. We then included over 20 specific paragraphs in the complaint that outlined and described the machine that was involved in this particular case, the safety guards that were on it to protect Brian and how they worked. We described the operator's manual that was provided to Myers Industries by the manufacturer of this machine, which warned them to not use the machine without all the safety guards on it. We described how Myers Industries made the conscious decision to have somebody, Bill Hartwick, make changes to that machine that would keep it operational, even though there was a part that needed to be replaced and they were waiting on the part replacement to come in. And we described how that decision resulted in the bypassing of an important safety guard that protected Brian from injury.
And counsel, it gets a little confusing because of the complaint, amended complaint, all those types of things, but in that amended complaint, did you specifically say that Myers Industry had the machine, I don't want to say repaired because it wasn't repaired, but altered, thank you, altered is a good word, altered in with the intention of removing the safety guard?
The short, do we do those exact words, no, but we described them, how that decision, effectively and essentially removed an important safety guard, bypassed a guard that comes with the machine.
Right, but did you say that Myers Industries actually knew that that would in fact, or did in fact, remove the safety guard or prevent the safety guard from working?
Did not allege in the complaint if they knew that was going to happen or not afterwards. Obviously, within days, they did an investigation and recognized that that decision resulted in it bypassing that safety guard and causing this injury.
Counsel, I have a question for you. Let's say
Sure.
for the sake of argument, and as you pointed out, as to the first assignment, the trial court's decision was 12b-6. It did not touch statute of limitations.
Correct.
Let's say for the sake of argument that you are correct in your assessment of what your complaint was. Wouldn't we have to know that it's timely?
I'm not understanding the question.
Well, but wouldn't it still have to meet the statute of limitations?
Yes, and we did
Okay,
through,
hang on.
okay,
I just want to make sure we're on the same page, because this is just kind of thinking this through in my head. But the trial court did not reach that decision as to this particular claim, correct?
correct.
How can wouldn't we be reaching it in the first instance?
What, the statute of limitation defense?
Yes.
Okay, well, I'm certainly can address that. If we go right to that, there is no statute of limitation defense, because by Rule 15,
Hang on. Before you spend your time reaching it, a decision would be made on that in the first instance by us, correct? We wouldn't be reviewing a trial court's decision on that issue because the trial court didn't come to a decision on that issue. Is that
Okay.
making any sense to you?
Well, I mean, I don't think the statute of limitation argument is a defense to this, because Myers Industries was a named party in the lawsuit before the statute ran. All we did simply was, once we found out this information, that they really had a role in this, then we amended the complaint and just added an additional claim for employer intentional tort against Myers Industries, which is something we're permitted to do under Rule 15. This very court in Perry versus Goff has reached a decision similar to that. In that particular case, there was an injured employee. They filed a negligence claim, a third-party claim against somebody else before the statute of limitations. That defendant on the negligence claim then brought in the plaintiff's employer as a third-party defendant. So everybody was in the suit before the statute ran. The injured employee then amended their complaint to include an employer intentional tort claim against his employer, and this Ninth District Court of Appeals said that was fine. It's saved by Rule 15. The amendment goes back, and there was no problem with that. So, okay, so that's why, the statute of limitations defense does not apply here. But just going back to the level of detail in the complaint, that in of itself, all those things that I rattled off, that should have been enough. But we didn't stop there. We then attached to the complaint an email between a management member of Myers and Bill Hardwick regarding what they wanted to do and why, to basically keep this machine running despite it having all of its parts. We included the actual wiring system that Bill Myers did that ultimately bypassed this safety guard, and his warning to them that you need to remove this as soon as that part comes in. And then we included the actual accident investigation form that Myers completed within days of Brian's injury that we were never provided until after the statute had ran. So despite all that, the trial court said Brian had not stated a sufficient claim, even though the court is to make all reasonable inferences in favor of Brian. Now, I've been doing this for 20 years, hard to believe. I've represented many injured workers on this type of a claim, some under the old common law standard, the Fife versus Geno standard, and then some on 2745-01. I've lost one case on summary judgment, but I've never lost one on a motion to dismiss. And in fact, if you look at the appellate decisions that have been issued since 274501 was passed, which was 2005, there's probably about 50 to 100 between Court of Appeals and Supreme Court. There's maybe one or two where the injured worker lost on a motion to dismiss. And that was a situation where the injured worker just pled boilerplate type allegations, kind of mimicking the language of the statute. That's not what we did here. This case is similar to the case that this very court ruled on earlier this year, Seaton versus City of Willoughby. That was on summary judgment. This court affirmed the denial of summary judgment to the City of Willoughby in an employer intentional tort case because there was evidence that the employer had disabled, not removed, disabled the parking brake on an asphalt roller that led to the employee's fatal injuries. And the facts pled in this case are similar in that we're alleging a safety guard was disabled due to a decision that was made and put in motion by Myers Industries. So therefore, we're asking you to reverse the decision of the trial court and allow Brian to conduct discovery, take depositions, and further investigate and develop the facts in this case. We're also asking the court to reverse the granting of the motion for summary judgment that was filed by Hartwick and Filter Specialties. That decision should be reversed because the discovery rule applies to this case. The discovery rule is an exception to the 2-year statute of limitations. Under the discovery rule, the statute does not begin to run until there's actual knowledge of the injury, which obviously Brian had on the day he got injured, April 3rd, 2014. But that's not where you end the analysis. It also requires actual knowledge that the injury was caused by conduct of the defendant. That information did not become available or wasn't known to Brian until May 24th, 2016, the date of that report from the BSSR investigator by the BWC. This case is similar to what the Supreme Court ruled in Collins versus Sotka, S-O-T-K-A. In that case, there was a teenage girl found dead in the woods. A defendant was later identified as the person who did it, and they were convicted of kidnapping and murder. The family filed a wrongful death claim against that person, but it was filed within 2 years of the court order finding the defendant guilty, but it was not filed within 2 years of the date of her death. The court allowed that civil lawsuit to proceed, though, because her family did not know that the defendant was the one who killed her until later. And they did not think it was conscionable to throw that civil lawsuit out based on the statute of limitations when that information was not known until much later.
You have about 3 minutes total left.
All right, thank you. The same reasoning applies here. Brian did not know about Hartwick and the role that he played in causing Brian's injury until May 24th of 2016, when his name was identified in the report in the BSSR investigation. Once that was made available, we asked the court for permission to file an amended complaint. The trial court let us do that, and we then brought in Hartwick and Filter Specialties. Hiding important information from the injured person until after the statute of limitations has expired is not something that should be rewarded by the courts. One question I know the defense is going to ask is, well, why didn't Myers provide this info to its injured worker? They knew what happened within days, and it would have been the right thing to do. It's something that normally I see employers do. If one of their injured workers are injured using a machine and there's a third-party product liability claim, oftentimes I'm invited in to, on behalf of the injured worker to do an investigation. They share information because they have every incentive in the world to pursue that claim because they have a subrogation right. Anything they paid out to the injured worker under workers' comp, they're going to get back if we make a recovery on that third-party claim. Here, it wasn't done for whatever reason.
You only have about 2 minutes into your rebuttal left. That's total.
Okay, all right. So, for those reasons, we ask that you reverse the trial court's decisions. Thank you.
May it please the court, my name is Joe Gross. I represent the appellee Myers Industries, Inc. I'm going to take 10 minutes, and as mentioned earlier, the counsel for the other appellees will take the time. This is a refiled case, as the court knows. It was dismissed both times against Myers Industries for failure to state a claim. We would ask that this court do the same, affirm on that basis as well, since we believe that the trial court's analysis was essentially correct. But if the court decides otherwise, we would ask that this court find that Mr. McAllister failed to satisfy the 2-year statute of limitations for employment intentional tort claims. And I'll answer your question, Judge Callahan, that I believe that this court can rule on that issue, even though that the trial court did not, because it's another way to affirm a decision. And I believe, since it's a matter of law, that you can do that. So on the Rule 12b-6 issue, the essential issue that needed to be alleged with particularity was that my client, Myers Industries, intended to injure Mr. McAllister. That's what Revised Code Section 2745.01 requires, and that's set forth in subsection A of that statute. Now, there's 2 ways that he could have alleged that in the complaint with enough particularity to not bring up a motion to dismiss. And the first way is that he could have proved intent. And I forget who asked, but did he allege intent? Well, in paragraph 36 of the complaint, he says, everything I alleged above and what we're going to find in discovery is intent. That's the intent to injure. So that's not enough. That was a conclusory sort of statement. So when you look at the specific allegations, we find in the complaint, this is all from the complaint, that the machine did not operate. The Myers called Mr. Hartwick in to fix the machine, and by putting this circuit in, he could keep the machine running. That's it. There was no intent to injure. There was nothing from Mr. Hartwick that told Myers Industries that if it made the machine continue to run, that somebody was going to get injured. There was nothing in there like that.
Counsel, but in some prior paragraphs, they do talk about how that Hartwick, with the direction and authorization of Myers Industries, bypassed and removed the interlock safety guard on the rear sliding safety gate.
Yeah.
Okay.
Yes.
Then they also say, Myers Industries made the conscious and deliberate decision to continue to run the ejection mold machine that was involved in this incident without an important safety guard it originally came with, and to expose its employees, including Brian McAllister, to the dangerous safety condition that decision created.
Yes.
How is that not alleging that they removed a safety guard and they knew that that was exposing their employee to danger?
Well, there was the safety guard was the safety gate. It was interlocked. That meant that as long as the safety gate was there, which is a guard, that people couldn't get hurt. The fact that this
Excuse me, counsel, just on that note, aren't those facts for trial?
No, there was, first
Be
off.
summary judgment.
Or summary judgment.
No, it was for a motion to dismiss because, first off, the machine, within the allegations, the machine wasn't running. A safety guard prevents people from getting hurt when the machine is running. Mr. Hartwood was inside the machine intentionally. He opened up the front safety gate, this is often the allegation, opened up the front safety gate intentionally, like he was supposed to change the mold. Somebody else opened up the rear safety gate, and the machine operated. The machine wasn't locked out, so within the Exhibit B on the complaint, what was the first thing that was a corrective action? The machine when you put somebody in a machine, the first thing you do is you lock the machine out. So where's the intent?
But counsel, no offense to you, but the arguments you're making sound like a great summary judgment motion.
I think it's motion to dismiss as well, because the allegations, when you just look at the I didn't bring up one fact that's not in the complaint. And that's why I think it's a motion to dismiss. And I think that's what the trial court said too. So let's get to your point, Judge Carr, and that is that circuit, which was bypassed, a safety guard? Now, it wasn't. A safety guard is defined, and there's lots of case law on this, Fickle being the one that I would ask you to look at, and that was basically affirmed in the Hewitt case, which is a Supreme Court case. And it says that a safety guard prevents an operator from getting into running machinery. That's what a safety guard does. So, and that's because OSHA, which Mr. McAllister's counsel brought up, OSHA has a machine guarding statute. This interlock wouldn't be part of it. Now, the safety gate on it, so if the machine is running, you would want to prevent people from getting in. That would be a safety guard. If you took off the safety gate and said, okay, we're going to run the machine without the safety gate on, that would be a violation. But that's not what this was. As long as that safety gate was closed, the machine could run at will, and there would be no intent to hurt anybody because the guards were in place. Now this bypass, maybe it was like an on-off switch. Well, an on-off switch is not a safety guard according to the Supreme Court of Ohio. The Fickle case talked about a jog switch. Sometimes, I'm not saying that all machine guarding has to be physical. For example, on punch presses where you put in a piece of steel and then you have a two-hand press, that effectively is a machine guard because the hands have to stay out of the machine. That's not the same with an interlock. The Downer case, which Mr. McAllister's counsel said proves that an interlock can be a guard, is not the case. If you look at that case, that was dealing with a tire shredder. And it had a hinged hood on it, which had an interlock. So as long as it was down, the machine could run. Well, they took off the machine guard, and then they took like tape to deactivate the switch. Well, the employer in that case said, well, that's not a machine guard, but the court said, no, we're going to look at the removal of the guard, and the interlock is one piece. So when you took off the guard, that becomes a safety guard. And that requires the deliberate removal of a safety guard. And deliberate, and I'm running out of time, deliberate means calculated. It means a slow and deliberate process of determining what's going to take place when you remove a safety guard. And nothing that was in the complaint to create that rebuttable presumption in subsection C talks about deliberate, which is more than intentional. Thank you.
Good morning, Your Honors. May it please the court. My name is Ali Ghazagi. I'm here on behalf of the Applebee's Filter Specialties Company and Bill Hartwick. Mr. McLaughlin started off very heavily relying on the discovery rule, which he claims is an exception to the statute of limitations in this case. But the 8th District of Ohio, in the case of Braxton versus Peerless Premier Appliance Company, has held that the discovery rule is inapplicable when a plaintiff incurs an immediate injury. And that's the kind of injury that we're talking about in this case. The discovery rule would be more applicable in the context where there is a latent injury and the injury is not immediately discoverable. In this case, however, the injury was immediate, and therefore the statute of limitations began to run immediately at that point. And as the trial court correctly noted, that the discovery rule refers to the discovery of an injury and not to the identity of the parties. Now, Mr. McLaughlin stood up here and he claimed that there's two components to the discovery rule. There's first, the actual knowledge of the injury, and second, actual knowledge of that the conduct was caused by the defendant, or excuse me, the injury was caused by the conduct of the defendant. But this two-part test has absolutely no basis in law, and more importantly, it completely turns the notion of the statute of limitations on its head. In one sense, if a plaintiff who suffers an immediate injury can wait around and add defendants to a case any time after the statute of limitations is expired, there's absolutely no incentive whatsoever to timely investigate claims, which is the entire notion of the statute of limitations in the first
Okay,
place.
so how could the plaintiff here have found out that a third party was involved and had actually altered the machine if the employer didn't indicate that's what happened?
There are lots of ways to investigate. You could file a lawsuit right away and seek discovery. There's ways that you can interrogate one or more of the employees. If the employer, and I should also mention that whether or not the employer in this case communicated something to, their refusal to communicate, who all was involved in the case has no bearing on my clients. My clients did not do anything whatsoever to conceal themselves. They made themselves known the entire time. There are ways for a plaintiff, that's the reason we have a statute of limitations. It's to allow, it's to give you sufficient time to investigate the claims to figure out exactly who are the parties and what is the nature of the claims. In this case, Mr. McAllister did not do anything whatsoever. He waited several years before he even attempted to find out who was involved in this case, and only did so upon coming across a BWC report that happened to mention my client's names. So there are ways to investigate the claim, just as any other plaintiff in a case, when they get injured, there are ways, there are avenues to investigate the claims, other than sitting around for 2.5 years before finally discovering it. Mr. McLaughlin also mentioned the Collins case, the Supreme Court case that he cited in his oral argument. The syllabus in that case specifically limited the holding to wrongful death actions arising out of murder convictions. There have been no cases in the 20 years since Collins has been decided where the rule in that case has been extended to a personal injury case in which a plaintiff is immediately injured, immediately aware of his injuries, immediately injured. And that's the kind of situation that we're dealing with here. Collins has absolutely no application to this case whatsoever. And if I may also address some comments that Mr. McLaughlin alluded to about the concealment, and something that I brought up earlier as well. The savings clause was another basis for tolling the statute of limitations, at least cited in appellant's brief. If I could just very briefly address that as well. We've talked about the concealment. There's been absolutely no attempts by my clients to conceal their identities. They're out-of-state residents, and the Ohio courts have consistently held that the savings clause statute in 2305.15A has no application, does not apply because it would be unconstitutional as to out-of-state defendants who are in Ohio solely for business purposes. So there is no concealment there, and furthermore, there is absolutely no attempt whatsoever to conceal their identities, and the discovery rule also is inapplicable in this case, and that therefore defeats both of the defenses to the statute of limitations that were raised by appellant.
In about a minute and a half left.
Thank you, Your Honor. Three quick points. File a lawsuit right away. That's what they said Brian should have done. Well, if we had done that, then we would have been facing one of Mr. Gross's motions to dismiss, and we wouldn't have had the facts to include in our complaint that we needed to survive such a motion to dismiss. He said we didn't do any kind of investigation. If you see in the record, that's not accurate. Within 4 months after this, I was at the plant at Myers Industries with my expert, and we did an inspection. Never told about what had happened and the involvement of Mr. Hartwick during that investigation at the facility. And then finally, in Collins, The rationale behind that decision was the court did not think it was fair to make this girl's family go do their own police investigation and track down her killer. Instead, she was allowed to rely on the investigation that was done by the police department and the prosecutor's office. Similarly, that's what we're asking this court to do. Let Brian be able to rely on the investigation into this incident that was done by the state of Ohio through the Bureau of Workers' Compensation. And once those results were available, he then timely filed his complaint. So for those reasons, we ask that you reverse the trial court's decision. Thank you.
Thank you both for your presentation, all of your presentations today. The court will take the matter under advisement and issue a written decision which will be mailed to all sides as well as posted to our website and that of the Supreme Court.
Thank you, Your Honor.
gentlemen.
Thank you, Your Honor.